From the Library of Congress in Washington, D.C.
Thank you very much. I now have the pleasure of introducing our next keynote speaker, Professor Jane Ginsburg. She will be talking about the most of moral rights, the right to be recognized as the author of the work. Jane really needs no introduction. But I will give you a brief one. She is the Morel Janklow Professor of Literary and Artistic Property Law at Columbia University School of Law and Faculty Director of its Kernighan Center for Law, Media, and the Arts. I think she's been extensively quoted on moral rights, so we're very, very pleased to have her here today. She's also my former copyright professor, so I'm really excited to have her as well. Thank you. With that, I'll turn it over to Jane.
Thank you very much, Karen, and I'm honored to be introduced by a former student, and thank you very much to the Copyright Office and to George Mason for having invited me to give this talk. The French revolutionary legislator, Le Chapelier, famously declared, of all properties, the most sacred, the most legitimate, the least attackable, and if I may say, the most personal, is the right the author has in the fruits of his labor. Descending from those rhetorical and foreign heights, I can affirm that the most moral, the most intuitive author's right is the right to be recognized as the creator of her works. In fact, most non-copyright experts, in other words, ordinary folk, think that authors do enjoy the right to be credited for their works. Of all the many counterintuitive features of U.S. copyright law, and they abound, the lack of an attribution right may present the greatest gap between perceived justice and reality. Even entities whose relationship to copyright is ambivalent, for example, Creative Commons, make attribution a default in their parallel copyright universe. Another example, many who lack enthusiasm for paying authors, such as many online platforms, pick your favorite, query who needs money when free distribution gives authors great exposure. Exposure, however, implies credit for the work. And of course, we have assumed an international obligation to credit authors. The United States, I believe, is the only country, including among common law countries, not to include attribution rights in its copyright law. Whether or not we can get away with non-implementation of Berne obligations, it is not a good thing to be an international scofflaw. Before I address the positive law and future prospects for moral rights in the United States, let's consider some arguments for why our copyright law should not include enforceable attribution rights. And I will say that I'll evoke three reasons, one theoretical and two practical. The theoretical one might put under the rubric of postmodernism, that attribution rights overvalue authorship, that they are a vestige of the romantic conception of authorship, and since we don't believe in that anymore, we shouldn't believe in attribution rights either, and there are variations on that theme with which I imagine you're familiar. The second argument I'll call the slippery slope argument. That is, attribution rights might be okay, but they will lead us to integrity rights, and we don't want integrity rights because, among other things, they limit other authors' creativity, or for that matter, the leeway that producers enjoy to revise works. Now, how do we get from that slippery slope? It's actually not the right of attribution, it's the right to prevent false attribution that can lead to integrity rights. Think of the Monty Python case that Peter, you evoked earlier this morning. There, the right to prevent association of the name with a work that Monty Python didn't create because it was so very much altered was rendered enforceable, briefly, under 43A. All right. Of course, we have a little Daystar problem that we'll evoke later. But I think that analytically, the right to prevent false attribution is not actually a moral right, even though many common law countries include that in their moral rights provision, because the right to prevent false attribution is the right to prevent the association of your name with a work you didn't create. What moral rights are about is the association of your name with a work you did create. Nonetheless, if you're going to have both sides of the coin, then you can see how the argument towards integrity rights gets constructed. The third argument is the most practical of all, which is it's simply too difficult to implement an attribution right in practice. Think of the mess in our current case law about who is an author. And that's even without the prospect of having an attribution right for actual creators, regardless of whether or not the work is for hire. So you have a multiplicity of potential authors. How are you supposed to recognize all of them? How are you going to decide which ones should be recognized? Even if you could recognize all of them, that would end up meaning tiny print or endless film credits that nobody looks at anyway, so it's not going to do authors any good. Now, I think that there are some answers to the practical objections that I will address in the rest of this talk. So let me first start with the sources of attribution rights. Some of these have been already evoked. There are international norms. There is the current state of U.S. copyright law, VARA and copyright management information. I have put in brackets various private ordering solutions. Can everybody see the slides? And I believe there will be a panel this afternoon talking about private ordering solutions. And then I'll talk about potential sources in the U.S. copyright law for the attribution right. All right, starting with international norms. Danielle and others have already evoked Berne Article 6 bis, right? And that includes the right to claim authorship of the work. Now, for reasons that will become apparent, I think that there is a more important source from U.S. point of view of attribution rights, and that's Berne Convention Article 10. This is the quotation right that provides that it shall be permissible. So this is not an option to states to allow for quotation rights. This is a direction to allow for quotation rights, subject to a variety of conditions, provided that their making is compatible with fair practice, so their extent does not exceed that justified by the purpose. This text precedes Article 9.2 in the three-step test, which echoes some of these considerations. Most importantly, however, where use is made of the works, mention shall be made of the source and of the name of the author if it appears thereon. So if your copyright law includes quotation rights, which it is supposed to, then there is an obligation to include the name of the author if the author appears on the source of the quotation. So a couple of questions. First of all, the three-step test doesn't say anything explicit about attribution rights. What's the relationship between 10.3 and 9.2? I would say that 9.2 does not override 10.3. 10.3 is more specific, and it's apparent when one goes through the drafting history of the various iterations of the Berne Convention that the three-step test was not intended to override the obligation to mention the name of the author in the quotation right. I could also point out that the third step does not unreasonably prejudice the legitimate interests of the author, is fully compatible with an attribution obligation, because one could say that not crediting the author unreasonably prejudices the author's legitimate interest. But there's still a problem within the Berne Convention, which is Berne does not define who's an author. And in fact, there are reasonable arguments, although there is also reasonable disagreement, that the question of who is an author is left to national legislation, and so work for hire is not necessarily incompatible with the Berne Convention. If that is true, then that could mean that the beneficiaries of these mandatory attribution rights would be limited to non-employee authors. Now, TRIPS has been mentioned a couple of times, that are the moral rights in the Berne Convention are not enforceable through TRIPS. Here's the text that says so, and that's how come we have managed to get away with not actually implementing Article 6 bis. But I would like to argue that the attribution obligation through Article 10.3 is not a right derived from 6 bis, and since the carve-out is 6 bis and rights derived therefrom, if the attribution obligation that accompanies the quotation right is not derived from 6 bis, it's enforceable through a WTO dispute resolution proceeding. And so takeaway number one from this talk, the attribution right is enforceable in the context of the quotation right, and I would be delighted if some government, France or otherwise, would like to bring an action against the United States for non-enforcement of that enforceable obligation.
We are not encouraging that, however.
Yes. Karen and I had a few back and forths about the description of this talk. The version that is in the brochure is a little more vigorous than the original. Well, not my original, but the Copyright Office's original description. And Karen wanted to make sure that the Copyright Office was not tarred with my attribution radicalism.
We are in full compliance with our international obligations.
Okay. Now, as I mentioned, the United States is an outlier, not only with respect to those suspect civil law countries, but also with respect to common law countries. Every common law country has an attribution obligation in connection with copyright exceptions such as fair dealing, which is not quite fair use, but there's some similarities, and some other copyright exceptions as well, subject to a reasonableness proviso, but nonetheless, everybody else has such an obligation. I'll also point out that the European Union has not harmonized moral rights, but in the Orphan Works Directive, there is a provision, Article 6.3, that requires the name, including the name of an identified author, if the work is disseminated under the EU Orphan Works regime. All right. So that's the international landscape. How about in the United States? As you can see, I don't think much of VARA, and I'm going to explain why I don't think much of VARA for this purpose. Now, Section 409B is interesting because it does say that the author's name shall appear on the registration information. However, that probably means the statutory author, and therefore this is not a source of attribution information for non-employee authors. And then the other possible locus for attribution rights is copyright management information. So let me talk about both VARA and Section 1202. So the definition of a work of visual art is extremely narrow. There are very, very few works that actually qualify for attribution rights, and probably the most significant limitation for works that potentially qualify is the requirement with respect to photographs that they be a still photographic image produced for exhibition purposes only. I don't think that such a category exists. It didn't exist in 1990. Maybe that has been created for purposes of compliance or qualifying under VARA, but it's a sort of a strange category, and in any event the image would be protected only to the extent that it fell within this category. Any additional images, if they didn't disqualify the photograph entirely, would in any event not be covered by VARA. So and this becomes clear when you then look at the scope of protection. You have the right to claim authorship of that work, but it has to be a work of visual art, very, very narrow category. To prevent the use of his or her name as the author of any work of visual art which she or she did not create. But that's not a general false attribution provision, because it only applies to putting the author's name on another, quote, work of visual art. Right? So very narrow in application. And with respect to the tie-in between attribution and integrity, again, it's limited to that very small category of works. So this plays out as follows. There's no attribution right for any work that doesn't come under the narrow definition of VARA. If the author's name is put on an artwork that she didn't create, but it doesn't fall within the narrow category, so it's not a photograph produced for exhibition purposes only, for example, there's no right. And of course, there's no claim for the reputation-harming distortions of the work if the work doesn't qualify as a work of visual art. So it's a tiny, tiny universe. It's a tiny universe that might have bad ripple effects as a result of the Daystar decision. This is the case that all moral rights advocates love to hate for reasons that I think Peter Yu has already made clear. But let me add one more. There is a suggestion in Justice Scalia's opinion of a preemptive effect that the only affirmative attribution rights that we have in the copyright law are in VARA. And, well, if Congress had intended to have anything more than that anywhere else in the law, that would be superfluous. So a law should not be interpreted as being superfluous, even though if you thought of this as a Venn diagram, you would have what VARA covers is like a pea in a watermelon. So it's the ripple to argue that the fact that there is a tiny shred of attribution rights in VARA, somehow that means that there can't be attribution rights anywhere else in any other law is, I think, sort of pernicious. So that's another reason to deplore the Daystar decision. All right, let's turn now to copyright management information. The locus for this is another international treaty, but the WIPO copyright treaties post-date TRIPS, so their norms are not enforceable through TRIPS. Our compliance is a matter of goodwill. Of course, we totally comply, but there's no, we can't be hit over the head if we don't comply. Now, And indeed, one could argue that we don't comply, because the text of the WIPO Copyright Treaty Article 12 and the equivalent in the WPPT, well, actually, never mind the WPPT, just stick with Article 12. The standard is this double knowledge standard, which, as we will see, is problematic, but if one knows that the removal or alteration will enable, facilitate, or conceal an infringement of any right covered by this treaty, so the new rights in the WCT, or the Berne Convention. Okay, the rights in the Berne Convention include the right of attribution. So under the WPPT, removal of copyright management information that leads to a violation of the attribution right is actionable. But if you look at our text, I'll just move ahead for a moment, the standard for our text is having reasonable grounds to know that it will induce, enable, facilitate, or conceal an infringement of any right under this title. But we don't have an attribution right under this title, apart from tiny, tiny vara. So that means that there is a disparity between the scope of the obligation in the WIPO Copyright Treaty and the way we have implemented that obligation in U.S. copyright law. So the mere fact of denying attribution through removal of copyright management information does not suffice to make out a violation of our provision. So what does make out a violation of our provision? A few questions that the courts have grappled with. What is copyright management information? Where must it appear? And the knowledge problem. There has been some dispute about whether copyright management information includes, is only digital information or is any identifying information as set out in the statute. I think the majority trend, the overwhelming majority trend today is that it's not limited to digital information. The text, after all, says including in digital form. Well, including implies that it also covers not in digital form. What's helpful here is that the statute lists among elements of copyright management information the name of and other identifying information about the author of the work. That, however, is that a statutory author, or is that an actual creator? We're back to that problem. We've narrowed the zone of beneficiaries of some CMI claim if it's limited to statutory authors. However, I think there is a means, if the Copyright Office were so willing, to include more actual creators, not just statutory authors, because the statute in number 8 gives the Copyright Office the power to prescribe other information. So the Copyright Office could say creators regardless of work for hire status. The problem is that copyright management information is not obligatory. Copyright management information is applied by the copyright owner, who may not be the author, and therefore there may not be a total alignment of interests. And I think the way the statute is written, which lists a whole bunch of elements and says any of these, that to me implies that there's no obligation, that you can't really read the statute to say if you're going to, you don't have to apply copyright management information, but if you are going to apply copyright management information, you must include all 8 of these. I don't think, much as I would like, I don't think that that's an appropriate reading of the statute. Other questions that Section 1202 has given rise to, which is where is the copyright management information? Does it have to be embedded in the copies themselves? The statute doesn't say that. Conveyed in connection with is pretty broad. And so if, for example, as was mentioned earlier, the Creative Commons licenses are explained on the Creative Commons website, you could argue that the combination of those icons plus the explanation together satisfies the requirements for copyright management information. Case law is divided on whether just having a copyright notice constitutes copyright management information. There's also questions about where this information should be placed. In some respects, it harks back to the bad old days of mandatory formalities and where you place the notice. You might lose your copyright if you place the notice in the wrong place. For some decisions seem to lead to a conclusion that if you don't place the notice in sufficient proximity to the element that you are claiming copyright management information for, then it's invalid. Now, the hardest part is the intent standard, because as I mentioned, it's a double intent standard. Let's look at 1202B. Although the reasonable grounds to know, the last part qualifies both 1202A and 1202B. So you intentionally remove, right? So there's a knowledge element there, or you know that somebody else has removed that copyright management information, but that's not if the first knowledge standard is met, it is also necessary to show that if you distribute or publicly perform and so forth the altered or removed copies of the works, you're doing that knowing that not only that the management information has been removed, but also that you have reasonable grounds to know that that removal or alteration will induce, enable, facilitate, or conceal an infringement of any right, and it can't be conceal an infringement of an attribution right because we don't have an attribution right. And that's where many of the cases fail, the attempts of authors to invoke 1202 as a means of protecting identifying them with the work. That it would have to be shown that the distributor not only knew that the information had been removed or changed, but that the distributor had reasonable grounds to know that removal would facilitate the infringement of violation of other economic rights. Now, sometimes that can be made out, as in the Agence France-Presse case against Morel, but there are a lot of cases where it has not been possible to make the link between knowing removal or knowledge of removal and reasonable grounds to know that will facilitate a downstream infringement of an economic right. So that is a problem, but I have to say that we didn't make up the double knowledge standard. That comes from the WIPO copyright treaty, but what doesn't come from the WIPO copyright treaty is the linking to the violation of an economic right as opposed to the violation of an attribution right, which is why I contend that as enacted, 1202B is of some help, but it could be better, and moreover, it's not consistent with the international text. I don't know if Karen wants to say anything about that. All right, so let's turn to the more positive aspects. What are the prospects for moral rights in the U.S.? And I've divided this into without legislation and then what if we actually had a statute. So without legislation, I think that one strong possibility is that the inclusion of attribution can already and should be taken into account as part of the first fair use factor. Right? Not necessary to rewrite 107 to add an additional factor, but as part of the nature and the purpose of the use, attribution could be taken account of. Now, I have to acknowledge that there is very, very little case law on this. there are maybe 2 cases that consider that failing to attribute cuts against fair use. But fair use is dynamic, and perhaps some courts, particularly if they were sensitive to my slam dunk international obligation argument, might interpolate an attribution element into the consideration of the first fair use factor. I think there are things that the Copyright Office could do to make Section 1202 more effective. I mentioned including authors regardless of their work for hire status. I also think that the Copyright Office could sponsor the development of best practices for identifying authors, and perhaps the next panel will talk more about that. That, as mentioned earlier, many common law countries include a reasonableness condition as part of fair dealing. So what's reasonable could be subject to development through best practices or other out of multiple stakeholder forms of consultation. That's the way Australia does it. The Australia statute delegates to best practices. So I think that as part of an accompaniment to a fair use inclusion of attribution as part of the first factor, there could be parallel development of reasonableness standards and also development as a practical matter of how are you actually going to implement the information about who is an author to be credited. And then there's the question of waivers. Now, although I've said very bad things about VARA, there is one respect in which I think VARA is pretty good, and that's on the waiver standard. And I'll return to that when we look at what a statute might include. But I think the Copyright Office could also develop the waiver issue. There was a study that the Congress directed the Copyright Office to prepare in connection with VARA for how the waiver practice was actually happening, but the study concluded that there was almost no information out there at the time that study was undertaken, but perhaps that could be revisited. Okay, now let's call this Let's Dream. What if we had moral rights legislation? I think it has to answer the following questions. Who are the beneficiaries? What violates the right? And the waiver issue. So in my world, a human creator, regardless of employment status, should be the beneficiary of an attribution right. I think that the monkey in Borneo does not have copyright or attribution rights, but human creators, as opposed to juridical authors, should have attribution rights. That doesn't tell you who is a creator who is entitled to attribution rights. But we do have case law. It's not always coherent, and it's subject to lots of criticism, but there has been an attempt in the courts to develop the concept of who is an author, usually in the context of joint works, because somebody comes out of the woodwork and says, I'm an author too. Not all of that case law is laudable. I'm thinking particularly of Al-Muhammad. But there is work percolating from the courts. Perhaps we could continue to develop the concept of who is an author and then import that to who gets attribution rights. All right, scope. I think that the duration should be the same as for economic rights. I do not think that attribution rights should be perpetual, even though from a kind of consumer protection point of view, I think that there's a consumer interest in accurate attribution, whether the work is in the public domain or not. But as a matter of copyright law, I think that the right should be coterminous with the economic rights. The right would be infringed by omitting the author's name, subject to reasonableness requirements, and as mentioned earlier, I think those reasonable requirements could be developed through a multi-stakeholder consultative process. The last suggestion I'm ambivalent about, false attribution. I said earlier that I think that false attribution is actually not a moral rights issue, and that common law countries have to some extent conflated unfair competition issues with moral rights. The only reason I would put it in is because of the Daystar problem. Peter, you mentioned that there's the broad reading and there's the narrow reading. Under the broad reading, there may not be a 43A claim for false attribution. Lower courts have by and large been taking a broader reading. I think that while we're dreaming, the better approach would be what Justin Hughes has suggested, which is to, quote, fix the Daystar gap by amending 43A. To deal with false attribution, and then I would take false attribution out of a copyright attribution provision. But if we can't fix the Daystar problem, then this is better than nothing, but I acknowledge that analytically it's a different set of concerns. And then waiver. I said that I thought that VARA was not bad on the waiver provision, except for the very last part. The very last part of VARA says that one author's rights waives everybody's. That is very bad. So I have rewritten it in red to provide that a waiver of rights made by one author binds only that author. So the co-authors do not lose their attribution rights. But otherwise, I think that that text is pretty good, and in our imaginary statute could go in as such. Finally, remedies. Again, from VARA, VARA does not make registration a prerequisite either to bringing a claim or to damages, statutory damages for a violation of VARA. I would import that into our attribution right statute. I think that the primary relief would be injunctive relief, right? The author wants her name associated with the work. And by and large, this would be prospective, but to the extent that there might be outstanding inventory, to the extent we still have hard copies, I think an appropriate remedy would include adding the author's name to those already produced but not yet distributed copies. And as for damages, I think it might be difficult to prove actual damages, but statutory damages might be an appropriate component. How much those statutory damages should be is another discussion, but I would be, I think, favorable to having some element of statutory damages. And I think we have some time for discussion.
Yes, I want to start off with just a quick question about the Daystar case, because I think that's something that people have mentioned as the linchpin of U.S. compliance in some sense. What would your view be of whether the Daystar case actually is a linchpin? So at the time that we actually it's complied with the Berne Convention, or said that we complied with the Berne Convention, Daystar had not actually come down. Would you agree that at that time our moral rights protections were stronger, or would you believe that they were actually still somewhat weak?
I think when we ratified the Berne Convention, it was possible to make a barely plausible argument that our patchwork, which importantly included 43A, sufficed. And I will say that Jack Kernigan and I wrote an article taking the position that that the patchwork could be sufficient. Now, I will also point out that we wrote that before the UK and other common law countries added explicit moral rights. Because one of the arguments was the United States doesn't need to have moral rights in the copyright law. What counts is whether you have a moral rights protecting result. It doesn't matter what the label is. And I'm sympathetic to that point of view. And then, but a corollary to that was just look at the Brits. They don't have any kind of explicit moral rights. They barely have any moral rights at all, and they're in the Berne Convention. So if they can do it, surely the United States can do it. That largely unspoken argument then became somewhat less persuasive when common law countries did start enacting explicit moral rights provisions. So that's another element that perhaps has changed the way one evaluates the question between 1988 and 1989 and post-Daystar.
And then just to follow up on the post-Daystar point, you had mentioned that some district courts are taking a broader reading of the Daystar decision. There is a debate in academics as to whether you should construe it broadly or narrowly. Can you kind of give a little bit more detail as to how lower courts are interpreting Daystar and whether that affects how we might use the Lanham Act for compliance with moral rights?
Okay, well, the first line of defense, which crumbled quickly, was, and Peter, you alluded to it, is that Daystar concerned a work in the public domain. And you may recall Justice Scalia's colorful language about a mutant copyright law, that the plaintiffs here were end running the fact that they failed to renew the copyright in the motion picture, and they shouldn't be allowed to get themselves a kind of de facto extended copyright by bringing the Lanham Act into service. So the narrowest reading would be that this, regardless of what the court said, on its facts, this was a case about a work in the public domain, and it doesn't prejudge or determine the assessment of a false attribution or maybe even a non-attribution claim with respect to a work that is still under copyright. Now, that didn't fly at all. And I think it's pretty clear that it didn't fly at all because of what the court said about origin. A false designation of origin does not mean the intellectual origin of the work. The court was very clear about that. It means, as Peter said, I think it was Peter, that it means the physical origin, the producer, distributor of the physical goods. That's all that origin in the Lanham Act means. Well, under that approach, it doesn't matter whether it's a false designation of origin or a non-designation of origin. If origin doesn't mean intellectual origin, then that kind of knocks the Lanham Act out as a source of attribution rights. The broader reading still is that some lower courts have attributed rather broad preemptive effect to Daystar to conclude that you can't try to work in attribution rights or false attribution claims under other theories of law. So that part, the very broad interpretation of Daystar, means that we don't have the Lanham Act as a source of attribution rights anymore, and we might not have some other common law theories as a source of attribution rights, and that wonderful patchwork that was evoked in 1988, 1989 is looking like maybe 2 or 3 very ragged strips.
And with that, I want to turn it over to the audience to see if we have any specific questions to Professor Ginsburg about how we might strengthen moral rights of attribution or whether we need to. Yes.
What I didn't hear in your talk about legislation was why we should have legislation implementing a right of attribution. Is it strictly because we agreed to in the Berne Convention, or are there other reasons affecting the public interest, why the general public would be benefited by adopting this?
I suppose the first answer is we did assume an international obligation. And in so doing, Congress supposedly took the public interest into account. When we ratified the Berne Convention, we thought that that was a good thing for the United States. And the Berne Convention doesn't allow reservations, right? So you can't say, well, the Berne Convention is a good thing except for Article 6 bis, or for that matter, Article 18, which we did not initially implement either. That was the provision that requires states, when they join, to restore the copyright in works of foreign origin that are still in copyright in their countries of origin. Then if they're out of copyright in the United States, they have to be, their copyrights have to be restored. And of course, there were a certain number of works that fit that bill because they were published without a notice of copyright. They went straight into the public domain, or their copyrights weren't renewed, and so they went into the public domain after 28 years, which is much too short under the Berne minimum period of protection. Or in some cases, they, in fact, the Golan case itself concerned works which, when they were published, were their country of origin was a country that was not a member of a copyright treaty with us. But Article 18 says that when another country joins the Berne Union, then their works have to get protected. So we had an international obligation, enforceable through TRIPS, to restore the copyright in Soviet works that had fallen into the public domain in the United States. Now, Congress made the determination that ratifying the Berne Convention was a good thing for, not just for authors, but for the public and also for the American economy as a whole, because even back in the 1980s, the ways we used to make money, like by making cars and steel and electronics, we weren't doing that so much anymore, but we were certainly creating and exporting an awful lot of intellectual content. And so we had an interest beyond the perhaps parochial interests of authors in having very good international protection. So that's, I guess that would be my first answer to the question about whether attribution rights are in the public interest. I would say at that highest level. I would say also that attribution rights are in the public interest, in part for what some might consider to be consumer protection interest, that the public has an interest in knowing who created this work, and that the author obviously has an interest, and that interest is not simply a vanity interest. I think that the Constitution conceives of copyright as creating an environment that will encourage creativity. And being recognized for your creation, I think, is very much part of that environment. And so I would say that the public interest is one that should be considered to be deeply rooted, not only in our economic interests, but in our polity.
Any other questions? Oh.
Hi, Carrie Devra, Center for Copyright Integrity. I was very excited when you were speaking. I'm thinking, oh, awesome. How is it nobody has gone after Google for doing exactly the violations you were talking about should not be done? I also wanted to raise a point about David Slater, the monkey photographer. Gotten to know him. I would consider what David did in what he's explained to me as set design. He worked for weeks with a monkey to encourage the monkey to become familiar. So just to keep points on something, a fact on point. But Google, look what they've done. They have walked away with all of our works. I took a picture of a picture I just did, sent it out to a colleague of mine. But that picture has now been taken from me. I'm not dead yet. I'm not life plus 70. So how is it that Google has escaped the liability of what you just so wonderfully described a liability existing for?
I think that question may go to economic rights as much as to attribution rights. On
It removes names all the time.
let me go. get back to that on the monkey. I think there have been a number. I didn't mean to be flippant. There have been a number of variations of the story. Some have been more, have given the monkey more agency than others. Under the maximal monkey agency approach,
Find a new term.
Right, up there with the Zika virus, right? I think that does not qualify. However, in the variations on the story where the photographer set the scene and all the monkey did was click the shutter, there are a lot of cases, actually, not only in the U.S., but in other countries, where it's exactly that scenario. The photographer has set the scene and somebody comes along and pushes the button. And courts generally consider that it is the person who structured the image, not the person who pushed the button, who is the author of the work. But this gets to the question fairly raised: if we're going to have an attribution right, we had better know who's an author. And in many instances, that's not going to be too difficult to figure out. And in lots of instances, there are indeed conventions about giving credit. One thinks about the Writers Guild agreements and such. It's the fact that at the margins it may be difficult to identify who is an author is not, for me, a reason to deny attribution rights altogether. On the contrary, I think we need to work on coming up with a reasonable and implementable notions of authorship. And I do think that digital media, CMI is not limited to digital media, but digital media, in fact, offer a lot of opportunities for robust author-identifying information.
Any other questions? Yeah.
I was going to circle back to this in RMI, but I'm curious, when you were talking about the AFP v. Morel case and in connection with the CMI information there, do you favor a more broad interpretation or a more narrow one?
I think that the claim could be made out in the Morel case because what Agence France Presse did was to make the picture available for other news entities to then reproduce and communicate it. So there you had there you could show that they had reasonable grounds to know that there would be a downstream infringement. But the facts don't always work out with the downstream infringement. You wouldn't have to worry about that if the removal of the attribution were itself an infringement, right, which is what the WIPO Copyright Act says. But then the question becomes, can you fix that gap between the international norm and our implementation of that norm? Is it possible to fix that without legislation, right? Or would it be necessary to somehow work in the words attribution in order to close the gap? And I think it would be nice if one could come up with a creative way to close the gap without legislation, because I'm not so sanguine about legislation. But if we are going to have legislation, that's a clear candidate. And I invite people to be creative in thinking about how you can somehow interpret Section 1202 to make it consistent with our international obligations. And there's, of course, there's no WTO action, right? Because the TRIPS Accord doesn't apply to the WIPO copyright treaties, which came later.
Okay, I argued for AFP in the Morel case, and my take is a little different on the case. It was, first of all, it was fascinating. The jury had no understanding at all about the DMCA. I mean, that was very clear. At the early part of it, the judge, there was no Morel name on any of the artworks. By way of background, he posted these. Initially, it was thought that he was a citizen journalist. Somebody stole them, a guy named Morel. So AFP initially takes him off Sorel's site and lists it, giving Morel credit. A few hours later, they find out it was Morel, and they always gave Morel credit. He was always in the tag. It said AFP Morel or AFP Getty, Morel as part of the distribution. There was never any time that his name was removed, because his name wasn't on anything. It wasn't on the website. It wasn't on his website either. So there was never any removal. There was never any distribution by AFP or its subscribers or Getty without attribution to Morel. What the jury seemed to have found, and again, it was convoluted because, well, we don't have to get into it, but it was that they associated. It said AFP, Getty, Morel, which is standard media information for source, distributor, and photographer. And it was that, since he wasn't affiliated, it seemed it was that misassociation that was the basis of the very small DMCA award. But there was never, and so which was kind of odd for us, because there was never any distribution. And the court also specifically did not, they ruled against the argument that they originally made, because they originally said this was going to be a $180 million case because of the DMCA going downstream. The court ruled not that the downstream users were not going to be counted as part of the DMCA damages.
I think that your account of the facts illustrates why it would be a really good idea to develop standards or best practices that the copyright office, might endorse for what is copyright management information.
I think we have time for one last question if we have any. Well, I think we're just 1 minute out. Do you have, I guess my last question is, do you have any predictions? You said you weren't that sanguine about the possibility of legislation.
Well, I think some of this is in your hands, right? And so I want to be sanguine about what the Copyright Office can do, because I think actually there's quite a lot that the Copyright Office can do, both enforceably and certainly morally. And I'm quite serious about, I think I said there were two takeaways. One is that Article 10.3 of the Berne Convention imposes an enforceable, through the WTO, obligation to credit the author in the case of the quotation right, and that much of what we consider fair use would fit within the quotation right, and therefore takeaway number two, that courts should start developing as part of 107.1 to take into account the attribution to the author, if it was reasonable to attribute to the author, and then the Copyright Office can tell us what's reasonable when it comes to author attribution.
Well, I want to take this time once again to thank Professor Jane Ginsburg for her talk.
This has been a presentation of the Library of Congress. Visit us at loc.gov.